The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Welcome to our ongoing coverage of the Minnesota murder trial of Derek Chauvin over the in-custody death of George Floyd. I am Attorney Andrew Branca for Law of Self-Defense, providing guest commentary and analysis of this trial for Legal Insurrection. Anyone interested in a free podcast version of our daily legal commentary and analysis of the Chauvin trial can access the Law of Self-Defense News and Q&A podcast, available on most every podcast platform, including Pandora, iHeart, Spotify, Apple, Google, or just get a simple RSS feed. You can get links to all of that at lawofselfdefense.com/free podcast. Today's content is sponsored by CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe, in effect, promises to pay their members' legal expenses if their member is involved in a use of force event, and those expenses start big and get bigger fast, folks. A typical aggravated assault charge, what can happen if you simply point your gun at another person in self-defense, don't fire a shot, don't hurt anybody, can risk a 10 or 20-year felony sentence and cost as much as $30,000 to $50,000 in legal fees to defend, and that's just for the pre-trial expense. If you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be useful to have a financial partner standing behind you to make sure you have the legal resources you need to fight the legal battle the way you'd want it fought. Now, I've looked at all these types of services you might imagine, and I found that CCW Safe is the best fit for me. I'm a member. My wife Emily is a member. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Okay, folks, let's jump into today. First, a quick overview. Today was a terrible, horrible, no good, very bad day for the prosecution to a degree that I haven't seen since the trial of George Zimmerman. If you have no more than an hour to watch the video of today's proceedings, then I urge you to spend 44 minutes watching the cross-examination of state witness Johnny Mercil, the state's use of force training expert, and 22 minutes watching the cross-examination of Nicole McKenzie, the state's medical care training expert. In both instances, the result can only be called a train wreck of a disaster for the prosecution. Indeed, after the judge dismissed Mercil from the witness stand, Prosecutor Schleider appeared visibly shaken and angry, and he ought to have, given the mauling his case just received. At one point, Mercil testified that he himself had personally kept the suspect physically restrained until EMS had arrived on scene, behavior which the state has been arguing for over a week was misconduct, criminal misconduct, murder on the part of Chauvin. Even worse, not only did the cross-examination of McKenzie by the defense also go badly for the prosecution, it went so badly that Nelson informed the court that he intended to recall McKenzie as a defense witness when he presented his case in chief. There were two other witnesses today, neither of which went particularly badly for the state, although in the case of one of them, I expect it was only because the prosecution was saved by the bell when the court recessed early in the day. That doesn't save the prosecution. That witness will be back tomorrow, and I anticipate that the defense is going to have a field day with him on cross-examination as they did today. But first, some housekeeping. Before the jury was brought into the courtroom, we heard some discussion about the complication of Maurice Hall, the reported drug dealer in the Floyd's Mercedes SUV, who announced he was going to plead the fifth if called to testify in the Chauvin trial. Now, Hall has a real problem. If he provided Floyd with the drugs, and it seems likely that was the case, the drugs that likely were the actual cause of death of Floyd, under Minnesota law, Hall is looking at third-degree murder. Naturally, he doesn't want to testify in the Chauvin trial, only to have that testimony used against him in his own prospective trial. There's no doubt that Judge Cahill will respect Hall's right to assert the fifth. The only question is whether there might be some areas of questioning in which Hall could participate that do not incriminate him. This seems unlikely to me, and of course Hall's own attorney doesn't want him to be compelled to say a word about anything. But Judge Cahill has asked the defense and state to write down the questions they'd like to ask Hall and Cahill will decide if any of them will be allowed. Incidentally, it's also worth noting that Hall, quote-unquote, appeared in court via video, and his background looks like, well, it looks like jail to me. Cinder block walls, visitor notification signs, the whole deal. I've seen my share of jails. That brings us to the state's first witness of the day, MPD Sergeant Kerr Yang, who's the Crisis Intervention Training Coordinator. I'm not going to spend much time here on Sergeant Yang, both because his testimony wasn't very interesting and because I want to get right to the juicy cross-examination of Murcell and McKenzie. I'll only note that Yang's testimony focused on crisis intervention policies of MPD, things like de-escalation, did little to advance any narrative of guilt for the state, especially after the defense on cross of Yang was able to get him to concede that all these policies were in any case contingent on practicability and safety of the scene and totality of the circumstances. In the interest of thoroughness, however, I've embedded Yang's direct, cross, and brief redirect testimony in the text version of today's content. And that gets us to the first interesting witness of today, State's witness, MPD Lieutenant Johnny Murcell, a use of force trainer, an expert on use of force training and policy for the Minneapolis Police Department. Interestingly, Murcell testified at the start that he was currently on medical leave. Now, a prior state witness, police officer, Sergeant, I believe it was Evans, who took over the Floyd scene from Sergeant Pfluger, had also testified that he was on leave. Of course, Pfluger himself had just recently retired. Maybe this is all a coincidence, or maybe the MPD is losing officers. In any case, when not on medical leave, Lieutenant Murcell works in the MPD training division in charge of use of force training and policy instruction. He was active in that capacity during the period preceding the Floyd events, during which Chauvin would have received his department use of force training and policy instruction, which is what makes Murcell's testimony relevant. Murcell is also a genuine fan of Brazilian Jiu-Jitsu, BJJ, saying, as many practitioners do in my experience, that he had, quote-unquote, fallen in love with the sport. This was elicited on direct questioning led by Prosecutor Schleider, no doubt to buttress Murcell's credibility, as was the direct testimony of Murcell about his expertise in hand-to-hand force techniques as both a trainer and a street cop who'd actually used them in the real world, and his mastery of MPD use of force policies. Little did Schleider know how Murcell's credibility would shortly boomerang on the prosecution. Now, Schleider did his usual routine where he portrayed use of force option as being cast in absolute and binary terms. If A, then B. If X, then Y. Any variance of this was either out of MPD policy or at least untrained by MPD, which of course is an entirely different matter than being outside policy or much less criminal. But in any case, it was a wrong act. Schleider made use of the MPD use of force continuum, that graphic, use of force continuum, and presented it in the most childish and sterile context possible. If at this level of the continuum, officer can do this, but not that, correct? And Murcell dutifully answered in the affirmative. But if at that level of the continuum, officer can do that, but not this, again, yes. Schleider would also pose simplified and hypothetical scenarios only minimally representative of what occurred with Floyd and ask if the use of, say, a neck restraint in that hypothetical would be reasonable. Of course, the answer from Murcell, as intended by that narrow and specific question, would be no, it's unreasonable. Missing from all this direct questioning, of course, was any context around the complex dynamics and circumstances that often surround a police use of force event. That Schleider wants to avoid any such discussion is understandable because doing so provides an appearance for at least reasonableness, if not outright justifications for Chauvin's use of force decisions and conduct with respect to Floyd. Another common routine we've seen before from Schleider, and he used here today, when doing direct on state's witnesses who have any purported use of force expertise, is to show them that photo of Chauvin apparently, but perhaps not actually, kneeling on Floyd's neck and asking, is this an MPD trained neck restraint? Invariably, the answer is in the negative. Well, that makes for a good headline, but in fact, it's not very informative on the legal issues of the case. Why? Because just because a technique may not be MPD trained technique does not make it outside of policy, does not mean it was legally unjustified, and certainly does not mean it contributed to Floyd's death, which is what the trial is supposed to be all about. Once again, Schleider touched on positional asphyxia, and once again I feel obliged to note that this doesn't really help the state prove Chauvin's guilt beyond a reasonable doubt in the context of Floyd's ingestion of a threefold fatal dose of fentanyl. Certainly, if I had to choose between being in two situations, one in which I was placed in a prone position while handcuffed for 10 minutes, and another in which I was forced to ingest a threefold fatal dose of fentanyl, I know what I'd pick, and quickly. There's simply no reasonable comparison between those two risks to life. So the direct questioning of Murcell was really just more of the Schleider show. We've already seen with other states' witnesses kind of checking the boxes, but not even all the boxes needed to support the state's narrative of guilt. And always by only exposing the jury to half the context, which is a dangerous ploy. Basing your narrative of guilt on only half the context is a dangerous ploy because we, thank God, enjoy an adversarial legal system, and that means the defense gets to pop right up and expose the jury to the other half of the content, the half consistent with a narrative of innocence. And in this case, they get to do so with your own witness. And that's precisely what happened with Murcell, and in a big, big way. On cross-exam, Nelson began by asking questions related to Murcell's time as a street cop, with a particular emphasis on the tendency of suspects being subject to arrest to come up with all kinds of nonsense about why they shouldn't be arrested that day. Is it a dangerous job being a police officer? Murcell answered, yes. Are people generally unhappy about being arrested? Very rarely are they happy, Murcell answered. Do suspects frequently engage in a wide variety of behaviors to avoid arrest, including fighting, arguing, making excuses, nonsense medical claims? Yes, they do, answered Murcell. Indeed, when asked if he himself had ever disbelieved a suspect's claim of a medical emergency as an apparent effort to avoid arrest, Murcell answered that he personally had done so. All of this, of course, undercuts the part of the prosecution narrative that is relying on Floyd's purported pleas and excuses about claustrophobia and anxiety and crying out for mama. Perhaps all of that is real, I don't know, but a reasonable officer must also consider that maybe much of it is simply an effort to avoid arrest. Nelson also once again put the issue of pressure and body weight techniques in a favorable light. The state wants to present Chauvin's knee in a negative light, as deadly mechanical asphyxiation, or, depending on the time of day, as a blood choke, as attested to by MMA expert Williams. In fact, however, the use of pressure and body weight to restrain a suspect was adopted by the MPD because it was a lesser intensity of force than the prior practice of using strikes to compel compliance, either barehanded strikes or with batons or even with weighted gloves. Murcell concurred with this view. The take-home message for the jury is that Chauvin's knee, far from being a public execution in a public street, was a lesser force than would otherwise have been required. Whereas Schleider wants to pretend that all of Chauvin's use of force and other decisions should have been based solely on the needs and desires of Floyd, Nelson once again had the state's witness concede that under the MPD critical decision-making model, the officer must consider a wide breadth of factors beyond just the suspect, including the officer himself, his partners, any bystanders, especially angry or threatening bystanders. Schleider had described use of force in a very static and binary way. Once the suspect stops resisting, the officer should stop immediately his use of force, period. But Nelson got Murcell to agree that if the suspect had been forcibly resisting the officer only moments before, that would be a factor weighing in favor of continuing to apply force even after apparent resistance had ceased. That is, it's not just what's happening in the moment that counts, but what happened prior to that moment as well. Schleider would pull this trick again with the last witness of the day, Jody Steiger from LAPD, acting as an expert witness for the state, and I don't expect it's going to work out well there for him either, but more on Jody Steiger in a moment. Now, additional factors that a reasonable officer would take into account in deciding how much force to apply and for how long included a disparity in size between the officer and the suspect. And as we know, the 6'6", 230-pound Floyd was substantially larger than the 5'9", 140-pound Chauvin, as well as the circumstance in which a suspect not only fought police, but fought multiple officers, exactly as Floyd did in this instance. When asked if additional use of force factors included if the suspect was believed to be on drugs, and whether being on drugs could give a suspect exceptionally great strength, Murcell agreed with both those statements. When asked explicitly if any of the video of the event showed Chauvin placing Floyd in a chokehold, in this context meaning a respiratory choke, but the term's been used with careless disregard for accuracy, Murcell was obliged to answer that it did not. There was never a chokehold. When asked if a carotid choke, or what MPD would refer to as an unconscious neck restraint, required both of the carotid arteries to be compressed, Murcell answered that it did. So much for the MMA expert Williams' testimony to the contrary. Further, when asked how quickly unconsciousness occurred when a carotid choke was placed, Murcell answered, less than 10 seconds. Clearly, then, Floyd was not being subject to a carotid choke for the large majority of the 9 minutes or so that Chauvin had his knee in place. Likely never was subject to a carotid choke. When asked if Murcell trained officers that a suspect who had become unconscious could regain consciousness, get back in the fight, and perhaps even be more aggressive than previously, Murcell responded that he did teach MPD officers that. This, of course, is a rationale for Chauvin to maintain his knee across Floyd's back even after Floyd lost consciousness. As noted above, Nelson also explored with Murcell whether there were circumstances in which it would be appropriate for an officer to maintain a neck restraint for a substantial period of time, and Murcell conceded that they were. Sometimes to maintain the neck restraint for however long it took EMS to arrive, asked Nelson. Murcell answered that he personally had maintained restraint on suspects for the duration required for EMS to arrive. To ensure we get the point, the state's own use of force expert testified on cross that he personally had engaged in use of force conduct that the state had been using to demonize Chauvin as an unlawful killer. That, folks, is not a good day for the state. Nelson also again re-emphasized the reality that the officer involved in the use of force event must consider not just the suspect, but also the presence of an angry and growing mob, observing what might well look like to them an ugly use of police force, and Murcell agreed that was the case. On the issue of providing timely medical care, an issue the state pushes with particular energy, Nelson had Murcell agree that while MPD policy is to provide care as soon as possible must take into consideration the safety of the scene, and that the MPD policy actually requires that it first be safe for the officer to provide care before the officer has the duty to provide that care. Indeed, factors such as whether a suspect had just been fighting with the officers was huge in determining whether an officer could reasonably provide care, especially if that care would be chest compressions requiring the suspect to have their handcuffs removed. Murcell answered in the affirmative. Later, on redirect, Schleider would attempt to diminish the damage of this bit of testimony by asking Murcell if bystanders merely taking videos would constitute a reason to not provide care. The answer, of course, is no. But that merely provided Nelson with a layup opportunity on recross to ask whether a mob shouting insults and outright threats would constitute such a reason, and that was the conduct of the mob in this event, and the answer to that, of course, was yes. Similarly, Nelson hit back on the state's emphasis on the whole recovery position narrative in the context of hypothetical positional asphyxia. Might there be circumstances that would prevent putting a suspect in a recovery position? Murcell answered that there were. If that all sounds bad enough for the prosecution, you ain't seen nothing yet. It was at this point that Nelson showed Murcell a series of photographs captured from the body-worn camera of Officer Lane and showing Chauvin's knee on Floyd from the angle down from Floyd's feet looking to Floyd's head. In photo number 1, where is Chauvin's leg in this image? On Floyd's neck or on his shoulder blades and back? Murcell, shoulder blades and back. And in photo 2, same thing. Photo 3, same again. Photo 4, same. That completely undercuts the narrative that it was Chauvin's knee on Floyd's neck that caused his death. Nelson also asked, are there circumstances like those already discussed where it would be appropriate to maintain presence of a leg across shoulder blades and back in order to ensure control of the suspect? Yes, there are, Murcell answered. For as long as 10 minutes, it's possible. Ouch. In other words, the use of the restraint can be justified not only to compel compliance of the suspect in the first place, but to ensure that the suspect maintains compliance moving forward, especially given the experience and concern that unconscious suspects can revive and be even more violent than they were prior. even if that restraint is being held in place for as long as 10 minutes. And that's not just for the safety of the officer, but also for the officer's partners, for bystanders, and even the suspect himself. That's just devastating for the state's narrative, and all of it coming from the state's own MPD use of force expert. It was after Nelson was done with Cross that Schleider attempted to salvage something from this train wreck for the prosecution by showing a still photo of the bystanders, pointing to some of them holding phones and asking if people taking videos was a good enough reason to maintain restraint, not provide medical care. Mercil answered that video taking by bystanders was not a sufficient reason. That's when, on recross, Nelson pulled up the exact same photo that Schleider had just used and pointed out that in the picture, MMA expert Williams was clearly being physically restrained from advancing on the officers by the arm of another bystander holding him back. Would the threat of imminent physical violence from bystanders be a sufficient reason to maintain restraint on a suspect, delay medical care? If the crowd's shouting they're going to slap the F out of you, that you're a P word, that you're a bum, would that be sufficient to cause the officers to be alarmed about the prospect of imminent physical violence from the bystanders? Yes, Mercil answered, it would. Now, there is, of course, more granularity and detail in the actual video of the cross-examination of Mercil. Again, I strongly encourage you to watch the whole thing. That's all I'll cover here in text form, but the direct, cross, redirect, recross, and redirect of Mercil, those videos were all embedded in the text version of today's content. And that gets us to the next great witness, state's witness, MPD officer Nicole McKenzie, who's the medical support coordinator, because the state's terrible, horrible, no good, very bad day wasn't over yet. Again, direct questioning was by Schleider, and again he used the same old playbook, provide half the context in a childishly simplistic form that stripped out all context and certainly ignored the totality of the circumstances. On direct questioning, Schleider had McKenzie testify about how officers had a duty of care to suspects, that Chauvin had CPR and other training that would qualify him to provide emergency care, and that such care must be provided by the officer even if an ambulance has already been called. This was all particularly the case if the suspect was unresponsive, if the suspect was in handcuffs, if the suspect was in a prone position, and all of that. And again, Nelson, I can only say, pimp-slapped Schleider hard on cross. On cross-examination, Nelson asked, isn't it true that you train officers to consider not just the suspect, but the totality of the scene? Yes, she replied. Isn't it true that police officers also have a competing duty of safety to themselves, their partners, to bystanders, that paramedics, for example, don't have, to the point that if the scene is unsafe, if the officers haven't already announced a code 4, all safe, that EMTs will stage a distance away until they are told safety has been achieved? Yes, McKenzie replied. And isn't it true that the safety concern might come not from the suspect himself, but from angry bystanders? Indeed. We keep seeing Nelson circle back to this reality about the bystanders, and it's a potent view of the events around Floyd's death. It raises the legitimate question of whether it was, in fact, the angry bystanders who, in effect, killed Floyd by interfering with the officer's ability to provide Floyd with the attention and care which he'd otherwise have received. Indeed, their angry presence compelled the paramedics to do a load and scoot of Floyd, delaying his effective treatment and resulting in further delays when the fire department could initially not find the relocated ambulance 3 long blocks away. Along these lines, Nelson also touched on a new issue, that of agonal breathing. This is a kind of last gasp, desperate type of breathing a body near death engages in, and is generally considered an ineffective form of respiration and a sign of really desperate physiological condition. Isn't it true, Nelson asked, that agonal breathing could be misinterpreted by officers as just breathing? Yes, answered McKenzie, in which case, of course, they would know it was agonal crisis breathing. Would this be a more likely misinterpretation if the scene were noisy, disruptive, had the presence of a loud, angry mob? It would, answered McKenzie. Again, did the mob effectively kill Floyd? Nelson noted that one of the CPR training slides previously shown by Schleider on direct questioning of Mackenzie had indicated that one of the reasons an officer could justifiably cease performing CPR was if the circumstances were not safe enough to allow continued CPR. Would that also mean that unsafe circumstances could justify not starting CPR in the first place, even where CPR would otherwise be warranted? Yes, answered Mackenzie. A highlight of the cross of Mackenzie occurred when Nelson pulled up another slide from the training materials. This one showed a picture of a type I've seen many times, intended to illustrate in dramatic form just how lethal fentanyl is. The picture showed a vial of heroin with a small bit of powder in it. That small amount of heroin represented a fatal dose. Beside it was a second vial with a much smaller amount of powder that represented a fatal dose of fentanyl. Finally, there was a third vial with a truly minuscule amount of powder that represented a fatal dose of a particular common variant of fentanyl. One can only imagine the effect this would have on a jury that's naive to the lethality of fentanyl. Of course, they know fentanyl's bad, at least as a street drug, but did they know how deadly it was? Especially given that death by fentanyl overdose is the obvious explanation for Floyd's death as an alternative to Chauvin's death knee. Naturally, recognizing the damage being done to their narrative of guilt, the prosecution raised an objection. There was a lengthy sidebar, and when Nelson returned to cross-examination, he immediately moved on to another topic. So perhaps Cahill upheld the state's objection to the vial image. But it hardly mattered, really, because the next topic for discussion was also incredibly damaging for the state, and made even more so, really, as we'll see. Nelson began to explore the question of excited delirium with Mackenzie. This was a topic that Mackenzie had trained MPD officers on, so she had expertise, and Chauvin would have received this training, so the knowledge is relevant to his decision-making with respect to Floyd. You'll recall that we can hear the officers discussing concerns about excited delirium on their body-worn camera videos. The importance of excited delirium for the defense is that it explains both a lot of Floyd's erratic behavior, raises genuine concerns of superhuman strength on the part of the already very large Floyd, provides a justification for the sustained restraint of Floyd's entire body from foot to head, as that's part of the excited delirium protocol for police, and more. Now, naturally, again, seeing the damage done to their narrative of guilt by this line of discussion, the prosecution objected and there was another sidebar. And when Nelson returned, he again promptly moved on to different questions, but we'll learn not because he was giving up on excited delirium and not without having yet another line of questioning for Mackenzie that would prove severely damaging to the state. Here, Nelson began to ask again about the reasons that arriving paramedics might do a load and scoot. Why that approach if the patient needs care? One reason, Mackenzie answered, was that the patient might need immediate care that can only be provided at the hospital, such as emergency surgery. Understood, replied Nelson, but might there be another reason? Yes, answered Mackenzie. And this might be hard to believe, she said, but there have been instances in which paramedics were attacked by an angry crowd. If that's a concern, the paramedics might do a load and scoot purely for reasons of their safety and regardless for what the patient might need. Exactly as happened in the case of the paramedics arriving at the Floyd scene. But wait, it gets worse. Is one of the reasons the ambulance might do a load and scoot not just the safety of the paramedics, but that the presence of an imminently threatening crowd would make it difficult or impossible for the paramedics to focus on providing proper care to their patient? Yes, answered Mackenzie. Boom. Again. Did the mob effectively kill Floyd? And that was the end of Nelson's devastating cross-examination of Floyd. I should make clear, not that Mackenzie was devastated. She was fine, any more than Meltzer had been devastated. Both were treated with respect by Nelson, and both came across as genuine professionals. Rather, the state's narrative of guilt was what was devastated. And it's not over yet, because Schleider did redirect. And on redirect by Schleider, we had a perfect classic example of why a lawyer should never ask a question unless he knows the answer he's going to get. Isn't it true, Schleider asked Mackenzie, that officers shouldn't expect to only have a duty to provide care under perfect circumstances? Sometimes the circumstances are imperfect. Often they're imperfect. Mackenzie agreed. So far, so good for Schleider. But then, in an effort to undercut Nelson's characterization of the bystanders at the Floyd scene as constituting a hostile crowd, Schleider asked Mackenzie for her definition of a hostile crowd. Her answer? A growing contingent of people yelling, being verbally abusive to those providing scene security, acting in a manner that could interfere with care. Boom. Exactly as the mob was conducting itself at the Floyd scene. Again, did the mob effectively kill Floyd? And it's still not over for the state. It was at this point, when both sides had completed today's questioning of Mackenzie, that it was revealed that the state had objected to Nelson's asking Mackenzie about excited delirium. Rather than fight that objection, Nelson took a different approach entirely. He informed the court that he intended to recall Mackenzie as a defense witness for his own case in chief. That's right. Not only was Mackenzie's testimony as a state's witness incredibly damaging to the state itself, when Nelson was limited to the role of cross-examination, limited by the state's own scope on direct, Nelson was going to bring Mackenzie back as a defense witness, where he would be in control of the scope of direct, and the state would find itself limited on cross. And that was it for the state's witness, Mackenzie, until we next see her as defense witness, Mackenzie. I, for one, cannot wait. So again, of course, the direct questioning, cross-examination, and redirect of Mackenzie, the videos of those are all embedded in the text version of today's content. Finally, the last witness of the day, partial witness, I guess I should say, was another state's witness, Sergeant Jody Steiger, Los Angeles Police Department, called as an expert use of force witness for the state. I'm going to cover Steiger only quickly here because the court day ended in the middle of his direct questioning, and the state's direct of their own witnesses has not proven particularly enlightening, even when the witnesses were apparently strong. And frankly, Steiger does not appear to be particularly strong or impressive as an expert witness. So I don't expect the state to garner much value from him. I mean, sure, I expect he'll say the words the state is paying him to say, that Chauvin's force was purportedly excessive, and he did so today. But that's what we routinely see from the state on direct of their witnesses. Although I have to say, even his direct today was pretty weak, really, and I don't expect that to improve tomorrow. More to the point, if Steiger proves as weak on direct as he appears so far, I expect that Nelson will make easy and bloody work of him during cross-examination tomorrow. But in the interest of getting this blog post out in a timely manner, so everyone can enjoy the cross of Mercil and Mackenzie, I'll leave my comments here with respect to Steiger and pick him up again after he's gone through the whole state's witness experience tomorrow. But regardless, the portion of Steiger's direct questioning that took place today is embedded in the text version of today's content. Okay, folks, that's all I have for all of you today. We'll be back again tomorrow morning for our live coverage of the trial proceedings, live blogging of the trial proceedings. So join us tomorrow morning. And of course, we'll have our usual end-of-day wrap-up commentary and analysis in the evening. So until then, I'm Attorney Andrew Branca for Law of Self Defense, providing guest commentary and analysis for Legal Insurrection. Stay safe.